we could make the rights of nature into legally enforceable laws. I think that's another big challenge which we're going to address very soon. It's a really exciting place to be. In the midst of all this doom and gloom and this ecological meltdown, it feels like the end of days, but the reason why I get up in the morning is because I met Thomas and Mari 4.5 years ago, and they made sense of environmental law. And one of the things they said, that environmental laws maybe don't regulate the environment, they weren't designed to protect the environment. Environmental laws merely regulate the rate of its destruction. They don't actually stop the destruction. And then very cheekily they said environmental laws only regulate environmentalists themselves. And the more I think about that, the more I get into my DNA, and the more it makes sense of all the battles that everybody here is involved in. You know, that idea that environmental laws treat nature as property, and more particularly dead property, is part of the reason why we're in this mess. So they offer a way out and they offer hope, and it's brilliant to see all the groups in Northern Ireland working with a number of councils. Donegal County Council has passed a resolution for Mananoma. Council has passed a resolution, Derry City and Strabane, Belfast, all recognise the rights of nature. And we need to start making this real. So I'm delighted that they're back. No idea what they've ignited. And it'd be really interesting to hear what's happening globally to advance the rights of nature. So Thomas is going to speak first, and Thomas is the Senior Legal Counsel for the Community, I always get this wrong because they changed their name, CDR, James, come on, Centre for Democratic and Environmental Rights, CDR, easy, and Mari is the Executive Director of Centre for Democratic and Environmental Rights. They've opened their mind in terms of the nature and the basis of environmental law. They've also opened their minds that protecting nature is also protecting humans and communities, because we're indivisible. And I think that idea is sometimes lost as well. When we're advocating for the rights of nature, we're advocating for our own very survival on this planet. And they've also voyaged with us. They have held our hands. They have been incredibly generous with what's happening in Northern Ireland. Even though they work in Bangladesh and Australia and Ecuador and Bolivia, and their home place in the United States, they have helped Northern Ireland immeasurably, and we're truly grateful. So I'm going to pass over first to Thomas, and then Mari's going to say a few words, and then Peter's going to help manage a conversation, question and answers at the end. So, and thanks to the School of Law for helping to organise this event too. So thank you.
So a big thank you to James, big thank you to Peter for making this event happen and for all the other work that they've done. So lawyers can talk forever. I have a clock, so that's the good news. We're going to keep it kind of short tonight and then open it up for discussion and Q&A. And we decided to break this apart by kind of me explaining why we're here and why we came to this rights of nature work, and then talk about where it's happening and how it's happening and why what's happening here in Northern Ireland and Ireland is so exciting in the scheme of things. And so with that, we're gonna take you back in time about 25 years ago when I graduated from law school in the States, in the state of Pennsylvania. And my last year of law school, we were approached by a bunch of environmental groups, community-based environmental organizations. These were groups that were trying to stop hydrofracking for natural gas, or mining, extraction activities in their particular community, or toxic waste incinerators, basically any of the hundreds of different single issues that communities organize around every day to try to stop harmful things from coming into their community. And that third year of law school, last year of law school in the States, we were asked to assist those folks to try to stop those projects from coming in. And the question I asked myself was, why did they need our help? You know, we had to explain to them that we were just students. We were still law students. And practicing law for us was illegal. We couldn't legally represent them. So eventually we ended up teaching them how to use the law library and how to become lawyers themselves, at least enough so that they could begin to challenge permits and do those kinds of things in the courts. Not here to talk about that tonight, but that was an interesting foray into kind of democratizing the law. We tend to think of lawyers as clerics in this church. that we have access to the law, we can read the law, we're like the chosen ones. But the truth of the matter is, when we come into a community to assist a community to fight, Waste Management Corporation or some other company in putting in a particular project, when we leave after that fight's over, the resource, the technical knowledge, it leaves with us. There's no residue left in the community. And so we decided to bring community activists along to create this new kind of category of community lawyers. But that last year of law school for us taught us of a need for communities that can't afford lawyers. Lawyers in the United States, environmental lawyers, charge, some of my colleagues in the corporate field at least, charge about $1,000 an hour to even look at an environmental permit application or to have a conversation with a community organization. And it's just beyond the reach of a community group who's normally trying to put, two nickels together, 2 quarters together to try to afford a lawyer for their particular problem. So we did something unusual that my law professors taught us we couldn't do, which was we created a nonprofit law firm, an NGO, that provided free legal services to these community groups. So we wanted to set up shop to actually eliminate that hurdle or obstacle for those communities to be able to obtain legal counsel to enforce the existing environmental laws in the United States. And for about 10 years, that's what we did. We had about 200 clients. These were those community groups that were fighting different things, mostly across the state of Pennsylvania, ranging from large-scale industrial water withdrawals to factory hog farms, to toxic waste incinerators, to extractive industries, to fracking for natural gas, all those kinds of things. And we had great faith in the U.S.'s environmental laws. They're always held out as a big success story. So we didn't question the laws themselves. At that point in time, we questioned the fact that there weren't enough lawyers to represent communities to enforce the laws. So we said the problem is not the laws, the problem is the enforcement of the laws. There's not enough people doing enforcement. So we set out to create more lawyers to do that enforcement process. So for about a decade, that's what we did. We filed permit appeals. We were in court enforcing the U.S.'s Clean Air Act and the Clean Water Act and all these seminal environmental laws that you're told, at least in law school, that we have in the U.S. We tried to make them work. And what we found ourselves doing was mostly running like a hamster around a wheel in terms of our job was when a permit was issued by the government for a particular project. Our job was to come in and try to overturn the permit, try to get it thrown out. And to get it thrown out, we had to take the corporation's permit application that had been submitted to the government, and we had to argue that something was wrong with the permit application. In other words, that the permit never should have issued by government. It was a mistake. And that a judge should overturn the mistake and nullify the permit that had been issued. And because in the U.S. there's so few environmental lawyers, there's only 200 full-time public interest environmental lawyers in the U.S. total. The number hasn't changed over the last 20 years very much. But that nobody ever shows up to challenge the permit applications. So 90-some% of all the permits issued to companies to carry out these bad projects in the States never get challenged. They just simply, the permits issue and then the corporation does what it does. So sometimes the goal in life, the whole enchilada is about just showing up. And so we would show up in front of judges and we would make arguments. We would say, Your Honor, under section little 2 little c little d little Roman numeral 2 little I little e little 2 little c little d of the regulations, that the permit application required the signature of the executive director on the permit application, and it's missing. Or they had to post a bond for $1 million for the roads, to take care of the roads from the truck traffic generated by the facility. And we'd say, well, there's not a $1 million bond, they only posted a $200,000 bond. Or there needed to be an invertebrate environmental study because this involves a river and a waterway, and there had to be a water study. The water study was done, but it was 20 years old. You get the picture. We were going line by line through the permit application, trying to find errors, gaps, or omissions about how the permit issued to argue that it was a mistake that the permit issued in the first place. And we won. We won a lot. Our win-loss record was something like 200 to 4. I mean, we would win these cases, and the judge would agree with us. He would say, absolutely, the signature is missing, the bond wasn't there, there needed to be the updated study, something had to be in place. He threw out the permit. We were then invited that night to a victory party by the community group, who invited us in for some beer and some snacks, and they would pat each other on the back and they'd say, the system works. We had a problem in our community. We took it to the courts. We found a lawyer who could speak somewhat intelligently. The judge agreed with us, and now we're not going to get the toxic waste incinerator. What happened 60 days later? Corporation would come back. And this time they'd come back and they'd fill in the gaps, omissions, and deficiencies that we had found. You want a signature? Here's a signature. You want a bond amount? Here's a bond amount. You want a new study? Here's a new study that we did. I had the lawyers for some of the largest corporations in the world come up after these hearings and thank me for finding the gaps, omissions, and deficiencies in the permit applications, because it allowed the law firms to go back and bill more hours to the corporation to complete the permit application to get the permit that would issue again. Okay? That was the situation we were in. And it reminded me of, somebody contemporaneously said to me a couple things that I didn't know about. At least we thought we were costing the corporations money. You go into court, you contest the permit application, they got to hire lawyers, the side's lawyer up, it costs money to be there. Well, guess what? Under the law in the U.S., that the monies that the corporations spend to defend the permit applications is tax deductible as a reasonable and necessary business expense under the U.S. tax code. So you have communities on one hand who are trying to finance these fights out of their own pockets by rubbing 2 dimes together and photocopies and gas and all that kind of stuff. On the other side, you have these giant corporations who are writing off the costs of the permit defense as a reasonable and necessary business allowance under U.S. tax law. It's structural. There was something structurally wrong. It wasn't just about finding a lawyer or going in and fighting it out under the existing standards that existed in the law. And we fool ourselves sometimes by saying that these laws are neutral, that we all develop them collectively and that they're all about environmental protection. But when you lift up the covers, you find that the folks at the table who wrote the regulations in the first place were the very corporations that ostensibly were supposed to be regulated by the regulations. Because when the Clean Air Act regulations were developed, it wasn't environmental groups sitting around the table to actually write the regulations. They didn't have the resources to do that. It was the regulated industry that was around the table that was writing the regs. I worked in the state capital of my state, Pennsylvania, for a number of years. I watched as the agribusiness corporations, who now, by the way, 4 agribusiness corporations control 80% of pork production in the world. 4 corporations. 5 corporations control 70% of chicken production on the planet. That I watched as the agribusiness industry in my state wrote laws and passed them off to the legislators to be passed by the Senate and the House in my particular state. It's almost like there's a myth that operates among all of us. It's like this gas of some kind, where we think that we live in a democracy. We think we live in a democratic state. But in reality, we're not allowed to do shit, right? We're not allowed to do anything. There's rules written so that when we come in the door on behalf of a community, it's like, to use a U.S. analogy, it's the bottom of the 9th inning in a baseball game and one hand is tied behind our back. Because everything's been developed before we get there. The law is developed before we get there. When we were lucky enough to punch a hole in some regulations in a way that they couldn't fix just by bringing back another permit application with a new signature, what did they do? They went to the legislature and put a patch in place, a legislative patch in place. They simply went back and filled in the hole through the legislative process. So we basically found we were enforcing the corporation's own regulations against them, in essence, when we went in and tried to tinker with these permit applications. And as James said, last time we heard, we used the same phrase, which is that someone smarter than me said it way back in the 1990s, that the only thing environmental regulations regulate are environmentalists. They regulate us because they make us predictable as to how we fight when these things come into the community. If you were a giant corporation with power to write the regulations, Why in the hell would you write the regulations to allow the community on the ground to veto the use that you're trying to make through the permit process of their community? Why would you do that? You wouldn't. And they don't. And that's why there's no right built in there for our communities to have a say. But there's a bigger problem with the environmental laws. And the bigger problem with the environmental laws, in the US at least, which have been very ineffective, for example, waterways, we've had the Clean Water Act in place for close to 40 years now. 60% of our waterways still don't even meet the minimum definition of fishable and swimmable that's contained within the Clean Water Act legislation at the federal level. They're just not working on their surface. But they don't work for a different reason. And the bigger reason that they don't work, or why they don't work, is why we're here tonight, which is that there's no deeper legal principle in environmental law, Western law in general, than that nature is property, that nature is owned, that ecosystems are property under the law. We used to, of course, in the States, have other categories of things that were categorized as property rather than rights-bearing persons. Women were not property, were property under the law until the passage of a constitutional amendment in the States. African Americans were property under the law until several constitutional amendments were passed. And none of this is perfect because, of course, both are still lacking under US law for certain protections and rights. But we have a legal system in which people's movements have transformed things that were once considered property into being rights-bearing. And today, ecosystems and nature are in that position. Doesn't matter whether it's UK law, doesn't matter whether it's law of the states, for that matter, doesn't matter who the colonizer was in different places, whether it was the Dutch or the Portuguese, all these kind of legal systems are the same. They're all dependent upon natural resource extraction and use. And to make that the easiest, you convert nature into property. That's how your legal system treats nature, is as property, non-rights bearing. And that's a problem. It's a problem that has basically created the situation that we have of major environmental crises that we're suffering now. By almost every measure, things are worse now than they were 40 years ago when some of these environmental laws, seminal environmental laws, were passed. In addition, the science, as the science tells us, we are now in the middle of a massive ecosystem collapse. Almost every major set of ecosystems in the globe is now in the middle of a major ecosystem collapse. It's because of the way that we've seen the world. Our Western vantage point has seen the world as property to be used, to be exploited, to be divvied up. I mean, think about how we do real estate. In the States, the people came in, they took over from the indigenous communities, and then they simply drew lines, borders around property, and then we created deeds, and that's how the whole deed real estate industry began. So the question is, where do we look for a different kind of approach? And in the States, at least, in the 1970s, we had this interesting dispute rise between the Walt Disney Corporation, so one of the largest entertainment corporations, who wanted to put in a ski resort in the state of California, and the Sierra Club, an environmental organization in the States that was positioned to try to stop the ski resort from going into place. You had a lawsuit developed between the Sierra Club and the Walt Disney Corporation, who wanted to put in a ski resort bigger than Disneyland. That's how big the ski resort would have been in this rural area of California. And the dispute basically centered on whether the Sierra Club had legal standing to be in court. And legal standing is this relatively complicated concept about whether you can walk into court or not, whether you can be a plaintiff. So not everybody can sue everybody, although it seems that way sometimes in our legal systems. But you have to have some interest that's been affected before you can become a plaintiff and walk into court. The courts in the 70s said that the Sierra Club and the Sierra Club members were not physically affected by the construction of the ski resort. They didn't own property near it. They were not otherwise affected by the construction activities. But that's pretty much been the test that's been applied, where are you physically impacted by the project, and therefore do you have legal standing to go into court to stop it? The lower court said, no, you don't have standing. They threw the case out. It went up to the U.S. Supreme Court, our highest court in the U.S., And in the US Supreme Court, they also threw the Sierra Club out. Why are we talking about this case today? Because of a dissenting opinion written by a Supreme Court judge, Justice Douglas, who was one of the most progressive environmental jurists ever to sit on that particular court, who wrote a decision that talked about the rights of nature. This is 1972. And in that decision, he said that the plaintiff here shouldn't be the Sierra Club. The plaintiff here should be the valley itself, which is being developed for the ski resort. So the valley itself, nature itself as a plaintiff, the ecosystem itself as a plaintiff. Number one, because that would eliminate this legal standing stuff about whether a human has interest in exploiting the ecosystem enough to be a plaintiff, but instead the affected ecosystem should be able to be a plaintiff in these kinds of lawsuits. What happened after 1972, after this case? The answer is nothing happened. Nothing happened for 40 plus years. It became an interesting conversation among lawyers and some jurists. People tossed the idea around, but nothing happened. Nothing happened on the ground until 2006 in this little community called Tamaqua Borough, just northwest of Philadelphia, a small community of about 7,000 people, who we were assisting to stop dumping of sewage sludge. So in the US, we take sewage sludge from our municipal treatment plants and we dump it on land where we grow our food, our ag food. I'm not sure what the status of sludge dumping here is in the UK, but sludge can contain several thousand different toxic contaminants. It's everything people put down the toilet or down the sink, ends up in the waste stream. And in the US, the way that we've decided to deal with it, has been to truck it from the municipal waste treatment plants and actually put it on ag land where we grow row crops, like corn and other things. Because of that, there have been several deaths that have occurred, mostly children. Immunocompromised children who live next to these sewage sludge sites who have died from things like Staphylococcus aureus, because different viruses and bacteria are carried also by that sludge stream. This small community in Pennsylvania called Tamaqua Borough decided that they didn't want to be a dumping site for this kind of sludge. And they asked us to write an ordinance or a local law that the municipality could pass, in this case, the borough or the city itself could pass, that would ban the dumping of that sewage sludge. And they came to us and said, we want to do more than that. We also want to protect our rights as people here, a right to clean air and clean water. As weird as it sounds, those legal rights are not really codified anywhere in the world. The right to clean water, the right to clean air, it's assumed that we have it, and there are little pieces of it found through environmental laws, but there's no legal human right to those things found in different places, including the states. So we decided to put human rights in there, human rights to clean air and clean water. And then we had a conversation with them about this 1972 court decision. And they asked us to draft the world's first rights of nature law, which would recognize not just humans as having rights in Tamaqua, but the rivers as having rights within Tamaqua. The right to exist, the right to flourish, the right to thrive. Basically, in a very practical sense, saying that human rights are one thing that are being violated by this sludge dumping. But rights of nature are another arena of rights or category of rights that are also would be impacted by the sludge dumping, because when we say the word community, we mean not just the two-legged people that are walking around, but the entire biotic community that we rely on, which is the animals and flora and fauna and the rivers and all the other ecosystems. And so Tamaqua became the first place in the world to adopt, I think to everybody's surprise, a legally enforceable, binding municipal law recognizing rivers as having legally enforceable rights within that municipality. So that's a lot to take in. That's the first place where it happened. But the idea here is that municipalities, local governments, creating rights of nature ordinances that recognize ecosystems as having rights, and more importantly, or as importantly, recognizing residents of the community as having the legal standing to step into the shoes of those ecosystems to defend those rights, which are recognized within those laws. So before I turn it over to Mari, the one thing that stays with me is that people all have different journeys getting to this place. And Peter's had a different journey, James had a different journey, Mari has a different journey. My journey came through that place of trying to make the existing system work for 10 years. And understanding that the environmental laws really aren't what we think that they are or what they're intended to be. And in the US at least, we've formed over 15,000 environmental groups over the past 20 years. They are funded to the tune of $8 billion a year. That's billion with a B. $8 billion, 15,000 groups. They're all doing that regulatory activism of environmental protection, trying to work through existing laws to actually protect the natural environment. And it's not working, whether you do it on a statistical, fact-based level, or you take a longer look out at this world that we're currently living in, where even the most optimistic projections of climatologists, for example, are turning out to be downright pessimistic in some ways. So with that, I'm going to turn it over to Mari.
And I wanted to thank Peter Doran for hosting us here at Queen's, and for James Orr from Friends of the Earth Northern Ireland and his staff for hosting this event and for having lunch and meeting with us today. They've been longtime partners, and we're really happy to be able to have returned here. A couple of years ago, it didn't seem like we were going anywhere. I'm sure you all feel the same, and it's really, really nice to be able to see people again in person. So thank you for hosting us again. So picking up where Thomas left off, this idea of environmental law, that Thomas's journey took him to a place of basically hitting his head against the wall. I kind of went on a similar journey, different steps, but ended up at the same place, in which I came to understand that environmental laws are legalizing the very harms that communities want to stop. And when we were here back in 2019, we met with folks who were fighting things like gold mining. And they're coming up against quote unquote environmental laws that are legalizing the mining to take place in their community, or legalizing in the States, we have fracking everywhere, and our environmental laws legalize the fracking, and our environmental laws legalize the industrial farming. All of the things that we think we're protected against, our environmental laws are actually allowing and authorizing to take place. And that's a pretty frustrating situation to find yourself in. And Thomas explained that nature is treated as property under the law everywhere around the world. And it's because of that that our environmental laws legalize how we use it. And it unfortunately draws on the very similar experiences that women and enslaved people and others have had over time, and that people's movements have had to fight, because they lack rights, they lack protection. And nature is sitting in that same place today. They're sit outside, if you will, the sphere of environmental protection, the sphere of legal rights. And the work of the rights of nature is really about transforming nature over here from being without rights, without these protections, and putting it into the sphere of rights, legal protections, essentially expanding what legal rights are including now. They now include women, they now include indigenous peoples, they now include children, they now include formerly enslaved people. That sphere of rights continues to expand as people kind of push against it to try to build more protection for more people and now for nature. And Tamaqua Borough in 2006 was the first place in the world to establish the rights of nature and law, and much to our surprise, a year later, we got a call from people in Ecuador who were working in their constituent assembly, which was drafting a new constitution. And Ecuador has, it has the Amazon, it has the Galapagos, it has all of these incredibly fragile ecosystems. And they were at the receiving end of extraction, of mining, of all of these things by multinational corporations from the US, from Canada, and elsewhere, pulling that country apart. And they understood they needed to do something different. They needed to change the way nature itself was treated under the law. And so we worked with them, with their delegates, to draft new constitutional provisions that for the very first time anywhere in the world, nature has enshrined constitutional rights within Ecuador's constitution. It remains the only constitution in the world to recognize that nature has fundamental constitutional rights. And that was 2008 that they ratified that in a nationwide vote. And what's amazing is what happens when something that big occurs. Because what Ecuador did was showed really to the world what was possible, that it was possible for humankind to have a different relationship with nature than one that's based on exploitation and extraction, to one that's focused on protection and recognizing that harm to nature is harm to ourselves, that we're part of nature. And Ecuador caused our phones to start ringing off the hook to say, if they can do it there, can we do it here? And so we have spent over the past almost 15 or so years now working at the most local of levels, such as the district councils here in Northern Ireland, local communities in the United States, local communities in Australia and elsewhere, to national levels and even international levels, helping government officials, meeting with court justices, meeting with local activists, meeting with civil society and NGOs to talk about what is possible. How do we change the status quo to move nature from being over here without legal rights to nature actually moving into that sphere of legal rights, which are the highest form of legal protection that we have in human written law. So today you have not only Ecuador has that constitutional framework, but you have national rights of nature laws in Panama and Uganda. You have courts in Bangladesh and Colombia and India ruling that all rivers and other ecosystems within these different countries possess legal rights. You have local communities in Australia passing rights of nature resolutions. We have communities here, as James mentioned, in Northern Ireland, district councils that have passed rights of nature resolutions. We have First Nations and tribal nations in Canada, in the United States, that have now moved rights of nature laws into their tribal and First Nation governing frameworks, and they're beginning to enforce and implement those laws. So we have laws occurring, lawmaking occurring at local levels, at state and provincial levels, and at national levels in different parts of the world, because from our experience, what we're seeing, especially over the last 5 years, tragically, as things continue to get worse with species extinction rates accelerating, with climate change, with ecosystem collapse, more and more people, whatever system of government they are in, whether they're looking at the local level or looking at their national level in whatever country they're in, coming to a common understanding that basically whatever we're doing isn't working. The status quo no longer works. Business as usual cannot continue. We have to remove ourselves out from under the existing environmental legal frameworks that we're all living under, and they're very much the same all over the world, and begin to renew a different relationship with the natural world. And it's not enough for us to change how we feel about nature or how we think about nature. That's important. That cultural shift is essential. We actually have to change how nature itself is treated under the law. And we have to change how we govern ourselves toward the natural world, which means changing our behavior, our decision-making, what we're actually doing as governments and as communities and municipalities, what kind of decisions we're making so that our activities, human activities, government decision-making, is no longer interfering with the health and well-being of the natural world. And that doesn't happen just because we feel differently about nature and value systems shift. We actually have to drive it into legally binding laws that we, humans, people in our communities, can actually enforce and guarantee. And that's much of the work that's happening now in Northern Ireland, is talking about how do we move this in through our district councils into bylaws, legally binding laws that we can implement and we can enforce, not just our governments, but also we, individuals, our residents of these communities who see things like gold mining coming in and knowing how devastating that's going to be, having the authority within our own hands to stop these kinds of things going forward. And that requires us raising the standard, the status of protection for nature, and actually recognizing that nature itself has legal rights. And the kind of rights that we're talking about is even that most basic right of all for nature to exist. That doesn't exist right now. That nature doesn't have even that basic right to exist. And literally, what does that mean? Well, I know, we've talked with folks in the UK who are fighting for the rights of peatlands. And, in the United States, for us, peatlands are basically wetlands that developers are constantly looking to fill in. And, they call it filling in, which means destroying them to build shopping malls. And that's happened in places like Florida where we've worked. That they just want to fill in, which sounds, it doesn't sound too bad. But really what they're talking about is destroying those wetlands, or what, peatlands equivalent here, such that, we're literally destroying the right of those wetlands or peatlands to exist. So what rights of nature laws start with the most basic right of all, and that's just the right to exist. And beyond that, things like the right to regenerate, the right to evolve, the right to be restored if harmed, if the rights of an ecosystem are violated, for instance. And as these rights and laws have been developing over the last 15 years, rights are getting even more precise, more specific. So for instance, a right of a river to flow, the right of nature to have a healthy climate system, the right to clean water, the right to clean air. In Ecuador, where the constitutional framework has been in place since 2008, they've had a number of cases go to their highest court, their constitutional court. And that court has been, I would argue, very robust in helping to understand what does it mean that nature possesses legal rights. And some people say, oh, you just want to give human rights to nature. And really, no, that's not it. Nature needs the protection that nature needs to be healthy and to have well-being and to be able to recover when it's harmed. And Ecuador's constitutional court has become even more and more clear about what that literally means. So for instance, they've talked about that, like migratory birds, for instance. Migratory birds need habitat along the way of their migration in order for them to survive on their annual migrations. So they need a right to migratory habitat. I don't need a right to migratory habitat. That's something very specific to migratory birds and other migratory animals. Others need specific kinds of wetland or peatland habitat or specific kind of temperature in the river water. And those are very specific to specific species and specific ecosystems. And so these rights are becoming more specific and better protective of what those ecosystems or a particular species needs. So we're seeing this work evolve before our eyes by courts, by lawmaking at all levels of government, by people of all different stripes who are seeing the need to do something fundamentally different. And that means taking ourselves out from under the existing system, which we know isn't working, and developing and putting in place a new system that we can force and that we can implement and that provides for the very first time the right of nature to even exist. Thank you.